All right, we are listening to these arguments about how the judge is going to deal with it because the state brought up the defendant's criminal record. I'd like to bring Francey Hakes into this conversation. She's a former federal prosecutor. Francey, I know you're there with us, so what's your reaction to this? My jaw was on the floor. You know, I mean, this is a big problem.
It is, Aaron. I mean, I'm shocked at the fact that the prosecution would either bring it out or let a witness talk about it. This is number one no-no when it comes to criminal cases. You cannot talk about any past criminal history of the defendant except in very certain limited circumstances, and even only then after the court has ruled it admissible. Here, the judge is saying that the defense did not object at the moment that statement was made about the defendant's criminal history, and that he thinks that was a tactical decision by the defense, and therefore they've effectively waived their right to object. This is very distressing because it may put if there's a conviction, it could put it in jeopardy for sure, like you said earlier.
I mean, exactly. So how does the appeals court bite into it if they get a chomp at the apple on this one, which I'm sure they will? I mean, I get the whole thing like, well, yeah, you've got to object contemporaneously and on the record, and it's got to be instant. But, you know, some objections you really don't need to do that to, and it's been a long time since I've ferreted out in my own memory which ones you have to and which ones you don't. Is this one of these ones where the appeals court can take a look at it either de novo, you know, take a first look at it, or is this something where they can kind of go between the covers here and try to dig it out and say, no, judge, they objected within a reasonable amount of time, we're going to take this issue up?
Well, it's the old adage, you can't unring a bell. And so the Court of Appeals, while they have all these different legalistic mechanisms to decide whether or not something should have been objected to contemporaneously, the bottom line is when it comes to certain kinds of evidence, those objections are kind of irrelevant because you're talking about something that is considered so prejudicial that the jury cannot be expected to lay it aside and will use it against the defendant in a way that is simply impermissible.
One last question on this, Francey. In some states, in some jurisdictions, I suspect this would have been a mistrial right off the bat. It seems like the judge wants to keep this thing rolling along. What's your analysis of the distinction, and do I have it somehow wrong?
No, I think you're exactly right, Aaron. And in fact, my very first criminal trial ever as a state prosecutor, something very similar happened to me where some evidence came in that discussed the criminal past of the defendant, and I just was not prepared to deal with it. I didn't know it was coming up, and the judge declared a mistrial. So it absolutely happens all the time, and I suspect in most jurisdictions it would have happened here, but it's a death-eligible case, if I'm not mistaken. So. Yes. All the legal wrangling ahead of time took a long time, and the judge just doesn't, it looks to me like, just doesn't want to stop and start over.
Well, look, I mean, they impaneled a jury that's going to be sitting there hearing this case for, what are we hearing now, 6 months, 8 months? I mean, the numbers kind of shift as the day goes on, but this case is moving very, very slowly. It may just be that the judge says, look, I'll try to keep the train on the tracks. By the time this goes to the jury, maybe they'll have forgotten about that piece of evidence. And look, it's difficult to impanel a jury of people that is willing to sit and listen to a case like this for that many months. The court administration probably doesn't want to go through that process again, but I keep going back to the defendant is the one that has the rights here. So, Francey, I know you're going to stick on the line with us here. A reminder, folks, that they are in a afternoon break, California time. We're waiting for live testimony to resume. In the meantime, let's listen back to some of the key testimony from earlier today from Mike McStay, the victim's brother, who talked about searching for the family when the family was missing.
The only way you would know that that actually had happened is if the defendant would. The only way that you would know that he actually did it is if the defendant told you.
Correct. Yeah, we talked on the phone.
Did you talk to the defendant on the night?
Yes, sir.
And tell us what that conversation entailed.
I don't remember exactly, but it was something to the effect of he was down there, he checked the water bowls, the dogs were outside, the shed door was open, he put a bag of food down or something, but he was going to be going down there throughout the week, he told me, so I didn't feel like I needed to run, rush down there.
Okay. So let me backtrack a little bit, or a little bigger picture issue. Did your brother and Summer have some connection with the Big Bear area?
That's correct. I believe at the time that her mother lived up there, and I thought they might have went up there to have a little R&R.
Did you have any contact information for Summer's mother?
I did not.
Okay. Did you attempt after the 9th and being alerted this, any attempt to call your brother on the cell phone or house phone?
I believe I did try.
Did you get any response?
No, sir.
That was testimony from earlier today from Mike McStay, the brother of murder victim Joseph McStay. Of course, Joseph, his wife, and his 2 children disappeared. It took authorities years to find them. Francey Hakes is on the line with me here on the Law and Crime Network as we cover this case into the evening. Francey, the big talk that we're discussing isn't so much Mike McStay and the connection that they're trying to use Mike McStay to say the defendant was acting nervous when Mike went over to the victim's home with the defendant. They were trying to get that into evidence, and that was the key point of Mike McStay's testimony. But look, I got to dial back to what Randy Zellin said here earlier with me on the Daily Debrief about an hour ago. He said, you know, the prosecutor's going through a lot trying to get that out of Mike McStay, and it seems like the prosecutor's nervous about having a weak case, and that was Randy's opinion. And then just a few moments ago, we had the prosecutor basically eliciting testimony about the defendant's criminal record, which is normally a huge no-no.
That's right, Aaron. It looks to me like this is the most circumstantial of circumstantial cases. I think something that people don't know is that there's direct evidence and circumstantial evidence just means evidence that suggests the guilt of the person. There's no eyewitness. It's perfectly appropriate. There's nothing wrong with it. It's admissible evidence. But here, it is not the strongest murder case that I have seen, especially when you're talking about seeking the death penalty. And so the strategy of the prosecution here is going to definitely come into question, I think, as the case goes forward, depending on showing that Merritt is guilty.
You know, I've got a big question here, and I'm sure jurors do too. From the opening statements, the defense said that there was unknown DNA found with the bodies that was unexplainable, and that results were requested by the defense, and the results would not be back for 2 days. Well, if I'm counting correctly, today would be that second day. I want to know what's up with this unknown DNA. What is going on with what was found when the bodies of these poor people were found in the desert there in California? What's the other DNA that's there in the burial site? And is that what's going to decide this case? Francey, look, you've sat on both sides of the criminal trial aisle here. That's a gold mine for the defense.
You're so right, Aaron. DNA is something that we rely upon so strongly now that didn't exist not all that long ago in criminal justice history. And when you have DNA from another random person that the state cannot account for, it is going to raise questions in the jury's mind. So it's going to be very interesting to see how the state handles that. Whose DNA is it? Is it in trace amounts? Could it be transferred DNA? Is it in more traditional forms, saliva, blood, or semen? All of these things are important for us to know to see how the state is going to battle against the defense claims, which is sort of the classic defense. We called it the Saudi defense, S-O-D-D-I, some other dude did it.
I hadn't heard that one before, but I'll have to add that to my list of things that people can bring up. So, look, I think we're going to listen to a little bit more of Mike McStay's testimony as we wait for this mid-afternoon break to grind along there in California. Jurors have been out for about 20 minutes now, maybe a few minutes longer, and we are going to actually take a quick break first, and we'll be back, hopefully with more live coverage here from the McStay family murder case. Listening to live testimony from Mike McStay, the brother of murder victim Joseph McStay in the McStay family murder case out of California. We're staying with this throughout the evening here on the Law and Crime Network, evening East Coast time, late afternoon West Coast time where this case is happening. I want to bring Francey Hakes into the conversation. She's been monitoring this along with me. Francey, a factual point here. This is really interesting because the defense is jumping through a lot of hoops to make sure jurors know that their client was actually in the house where the prosecution claims the crime happened. It's really interesting, but we remember from openings that the defense said that their client was trying to help find them. This was some altruistic thing, but it's still a really interesting strategy. Rarely do we see a defendant trying to put himself where the prosecution thinks the crime happened.
Well, that's a really interesting point, Aaron. And sometimes the defense does that because they're trying to explain away physical evidence that puts the defendant at the scene. And so what they're trying to say is, oh, sure, he was at the scene. He wasn't at the scene of the actual crime, the murder itself. He was at the scene later just trying to figure out where the victims were. So I don't know if there's any physical evidence that puts him in the house. I think the other thing that's interesting here is the defense attorney is trying to make the victim's brother look either like he's lying or has a terrible memory or is making up the discomfort on the part of the defendant when he went in the house to look to see whether they could find where they might have gone. Yeah, and so that to me is very significant with respect to the defense they're building.
They're forcing him to go back through all these records, which he's continuing to review now, and it was all because on direct he couldn't remember, if I'm remembering this properly, exactly where the defendant was when they were trying to get in the home on the 13th. And he said in a police interview that the defendant did enter the home with him that day. And there's specific reasons why, discussion about phone calls and a phone and all this other stuff. And he's like, oh, yeah, okay, well, that's what I said. Again, so there's a couple reasons for this. A, it's to get the defendant into the house for kind reasons to try to help. That's one thing. And, B, to try to get out from underneath what this witness said about the defendant feeling uneasy about going into the house. So a couple different things. It's just taking forever for it to come out on the witness stand. So let's go back in as testimony continues. We continue our coverage of the McStay family murder case out of Southern California with brother Mike McStay on the witness stand right now. It's been a big back and forth cross-examination. It looks like we might be heading towards redirect, but I do want to say goodbye to my evening guest here on the East Coast, Francey Hakes. She's been with me for about an hour here on Law and Crime. Francey, I know you need to hit the road. It's late. It's the East Coast, but party on. Continue watching the case if you can.
I will, Aaron. Thanks for having me on.
Okay. We're going to dip back into live testimony, though, in that courtroom from Mike McStay.